Good morning. The another minor act for which you have to concentrate some questions, some important provisions. That is Medical Termination of Pregnancy Act 1971 and recently amended by Act 2021. This act recently Supreme Court full bench consisting Justice Dhananjaya Y. Chandrachud held in X versus Principal Secretary Health and Family Welfare Department of New Delhi. Number 1, they say under Section 32H6 Medical Pregnancy Act 1971 and Medical Termination Pregnancy Rules 2003. They held all unmarried single woman without partner, all women are eligible to terminate the pregnancy up to, that is most important, 24 weeks under 3B. Then the purposive interpretation was introduced. Then they say there should be, the opinion should be from registered medical practitioner. There should be opinion also. They have also discussed about the social stigma surrounding unmarried women. Then another important aspect, Penal Code 312, 313, 314, 315, 316, 317 and 318 all deals with the child in the womb. So that is most important. Causing miscarriage, injuries to unborn children, exposure of infants, concealment of birth, all are offences punishable. They say the judge should only act the statutory directions, not by his personal opinion. That was also they have stated. Then the injury to mental health was also discussed. I am slowly coming. The right to live, right to live has been periodically extended. Right to live with dignity, right to live with free air, right to live with standard medical facilities, right to education, all were extended, Article 10. Now they say right to reproductive autonomy. They say right to reproductive autonomy. They say under Article, woman alone has right over her body and she is ultimate decision maker whether to undergo an abortion or not. It is her right. Then say forcing women to continue with unwarranted pregnancy would violate right to dignity. Article 21 they also discussed about article. Then most important, we should always concentrate that not only fundamental rights, the next chapter fundamental duties, then the policy of the government. There under Article 51, they have said under Article 51 which mandates that the state government must give respect to international law and treaty obligations. So here the Protection of Women Rights Act 1993 recognizes international convention and treaties at par of human rights law. Therefore that also to be considered. Then they say under, that is most important, under Article 32 Class 2 and 47. They say the state government obligation is for termination of pregnancy. All this has been discussed at various chapters. This is a doctrinal dissertation report judgment. They have table of contents is background, submissions, Medical Pregnancy Act, rules, and RMP, fear of prosecution. RMP means registered medical practitioners, dealing with 414, 415 and all other IPs. Social stigma, rule of purposive interpretation, transcending the institution of marriage as a source of right. So many aspects they have discussed up to I. Therefore, keep this mind, and this you have to go through this Pregnancy Act, and particularly you have to concentrate that there was an amendment 2000 there was an amendment of the act that was discussed, article 2021 Medical Termination of Pregnancy Act as substituted by Act 2021 3 subclass 2B. This is most important. All this you have to say how when this Termination of Pregnancy Act was amended, giving effect to terminate the pregnancy for all women. It's most important. I think you follow it. Best wishes.